Dominic says, emphasize how compliance moves the bottom line. That's a good point. The other thing I would share with you is that, in a very real way, compliance can improve your bottom line. HSBC Holdings PLC, I read this last week in a moneylaundering.com compliance advantage electronic newsletter. They pointed out that authorities in the United States were contemplating imposing a US $1 billion, up to US $1 billion in penalties for money laundering related breaches. This is one organization facing potential penalties of the order of US $1 billion. It's important, I think, to point out to management that there's serious consequences for non-compliance. And what we've seen in Jamaica is actually the authorities in Jamaica are showing a greater willingness to take very strong action whenever there is non-compliance. There is one bank which had to face charges in court for breaches of the Money Laundering Act. The Money Laundering Act, you know, was replaced by the Proceeds of Crimes Act in 2007, along with some other pieces of legislation. That financial institution was able to argue successfully before court that it had a valid no-case submission. And so the charges were dismissed, but the fact that the authorities took the institution to court shows that the authorities in Jamaica are not going to be averse to taking very strong action. And we should be convincing management, convincing staff of the importance of compliance, just for the simple reason that we don't want to be faced with criminal prosecution. Under the Proceeds of Crimes Act, for a breach of the provisions in that act, which are criminal offenses, there are serious consequences. Some of them include the possibility of a prison sentence. Derek says, are you saying no untouchables? Yeah, that's the world we're living in now. And, you know, it's very clear when you read about the action being taken. I read today as well in an electronic newsletter that a particular bank in the United States, the members of the board of directors were being fined by the Office of the Comptroller of the Currency. They're not just simply fining organizations, they're fining the persons who are accountable within the organization. Colleen says that I would like to see in Jamaica, and I'm saying, you know, there certainly is that kind of approach and attitude now. The regulators are showing a propensity to taking very strong action whenever organizations are not towing the line. We've seen recently when one of the regulators published notices concerning two entities, one a securities dealer, one another entity which appeared to have been breaching the Securities Act. So certainly that's just, I think, one in a series of examples of very strong action being taken by the authorities in Jamaica. Dominic says, you know, a corporation is a separate legal entity. Yes, corporation is a separate legal entity, but individuals within the corporation have particular responsibilities, and some of them are responsibilities laid out in statute. And so if those persons don't carry those obligations, or if they commit an act which is an offense, then the authorities will come not only at the organization but at the individual concerned. In the Proceeds of Crimes Act, certain disclosures are would be an offense. It would be an offense to tell a customer that you are going to file a suspicious transaction report on that customer. And so the individual who does that would be liable to prosecution under the Proceeds of Crimes Act. It would be an offense not to report a suspicious transaction act to the designated authority. In other words, it would be an offense not to make an authorized disclosure under the Proceeds of Crimes Act. So the person who fails to make an authorized disclosure when they know they should, right, in the face of evidence that customer is quite likely dealing in the proceeds of crime, and you do not report that to the relevant person, whether it be the FID or the nominated officer in your organization, then you are guilty of an offense and liable to prosecution under that act. Colleen makes an interesting point about what is currently happening now. We're seeing in the environment in Jamaica a number of persons who hold public office are coming under serious scrutiny and pressure. And a lot of that appears to be coming from overseas. We're reading about this in the newspaper almost every day. And that's a sign of the times, a sign of, I think, trend which is not likely to abate. As a country like Jamaica, which has benefited from significant financial assistance, we cannot expect that it's going to be business as usual. There will be greater transparency demanded, and in fact, going to seek to enhance our legislative framework, and we're going to seek to give the regulators more clearly define what the powers of the regulators are. And we should, we should not think that the regulators with more enhanced powers, that they're not going to use those powers. I believe they will. Throwing out a question to everybody. Which laws or requirements do you think are most challenging for companies to comply with? As companies doing business in Jamaica today, which ones do you think are most onerous? Okay, a consensus seems to be that KYC requirements are perhaps the most onerous. One person said capital requirements, they differ. Capital requirements are not uniform across the financial sector. The banking industry, the deposit-taking world is based on a Basel I standard, which looks on capital base to risk-weighted assets. Risk-weighted assets are determined by applying percentages to assets as well as to certain other exposures. Similar Basel I methodology is currently being used for securities dealers, although the FSC is proposing to change that by going to an approach that is more consistent with what is called Basel II, which not only looks at the risk-weighted assets, but also looks at operational risk exposure, market risk exposure, liquidity risk exposure, limits in terms of exposure to any single party. And they put out a consultative paper on that. The changes being proposed by the FSC are significantly different from existing capital requirements. So certainly in terms of the securities dealers having to meet the new requirements as proposed, I think presents a very interesting situation. I'm aware that the Jamaica Securities Dealers Association has prepared a paper on this particular subject, so it'll be interesting to see the outcome of that. The point I want to make here is that when we find that requirements are onerous, what should we do as businesses? Do we just simply say, well, this is the law, I'm going to have to just try and comply with the law? Or do we take a step back along with the other businesses which are in our sector, in our industry, that have to comply with the same law? And do we say, well, should we or should we not approach the authorities to have them change the law, because this is simply too onerous? And what is it that determines whether or not a requirement is onerous? And I think it should be that the cost of complying with the requirement far exceeds the benefit that is derived from having that particular requirement in place. That should be the basis for any law, any requirement. What it takes to comply with the law, what the law costs, should not exceed the benefit derived from having that law in place. If the benefit is less than the cost, then why have the law? Why have that law? And so that's the key point to be made here, is that organizations need to look at, well, this particular legal requirement, we think the cost of complying far exceeds the benefit. It doesn't mean that you're going to jump up and going to break the law. That's not what I'm advocating here. No, it means that you sit down with your competitors, the other persons who are in the same industry as you, who are affected by the law, and you come up with a position paper, and you present that to the authorities, whether it be the regulators, whether it be the government, whether it be parliament, to say, well, listen, we think this law should be changed. We might not persuade the powers that be that to change the law, but I think it's worthwhile the effort if you really strongly feel that a particular law is far too onerous and, in fact, may be inhibiting the growth of the economy. That's something that we have to look at, that too much regulation can inhibit growth. Dominic says, I can't remember. I've seen a position paper on compliance. No, but position papers, I can tell you definitely, Dominic, position papers have been formulated by industry groups on various issues, because the regulators, one good thing about our system in Jamaica is that the regulators are committed to having consultation and dialogue with the industries that they regulate before any new law is imposed, for the most part. And so you go to the website of the FSC, for example, and you will see discussion papers on various proposed requirements. And so those proposed requirements, before they are enacted in law or they become a guideline,